Imagine a whole country literally rewriting its legal DNA overnight. Just boom, completely changing the rules of the game. Welcome to the explainer on the landmark constitutional court case that defined exactly how South Africa's new democracy handled the ghosts of its past. Today, we're looking at Plessis Gert de Klerk. It's a fascinating legal battle that forced a brand new constitutional court to figure out exactly how and when the nation's fresh human rights protections actually apply to everyday citizens. We're going to use a high-stakes defamation lawsuit as our roadmap to explore some massive, abstract constitutional questions about human rights and time. We'll be covering the defamation lawsuit, the constitutional plot twist, the retrospectivity question, vertical versus horizontal rights, influencing the common law, and finally, the verdict. Let's get right into it.
Section 1. The defamation lawsuit. Let's dive into the inciting incident, because our story begins in the realm of private civil law, way before any grand constitutional debates even show up. Picture this. It's early 1993. The Pretoria News drops a series of explosive articles accusing Gert de Klerk and his aviation company, Wonder Air, of running illegal pirate flights to secretly supply UNITA rebels in the Angolan Civil War. They basically claimed these guys were fueling a devastating foreign conflict just for personal gain. Well, this prompted a staggering 5.75 million rand defamation lawsuit from de Klerk and Wonder Air. To put that into perspective, 5.75 million rand back in 1993 was an absolute fortune. We're talking an extraordinarily high-stakes showdown here. Now, you have to trace exactly how this unfolded chronologically, because timing is literally everything. In February and March of 93, the articles are published. By May, the lawsuit is filed. Then we hit a monumental historical shift. South Africa enacts its brand new interim constitution in April 1994. Notice that gap. The publication and the initial lawsuit sits squarely in 1993, under the old legal regime. It wasn't until October 1994, several months after the new constitution dropped, that the newspaper attempted a really wild legal maneuver by amending its plea to include a brand new defense. Which brings us to Section 2, the constitutional plot twist. The newspaper basically argued, wait a minute, we now have Section 15 of the Constitution firmly protecting freedom of the press. Therefore, our 1993 publication should be protected. This forces us to ask a deeply provocative question. Can a newly minted constitution retroactively protect you from a civil wrong committed before it even existed? Does the arrival of an entirely new legal order in 1994 suddenly make unlawful defamation from 1993 okay?
Section 3, the retrospectivity question. To answer that, the Constitutional Court had to clear the very first hurdle of legal theory.
They had to determine if the Constitution was retroactive. Acting Justice Kendridge was super clear here. The Constitution does not work like a time machine. It doesn't automatically reach back and turn conduct that was unlawful in 1993 into lawful conduct today. Think about it from a standpoint of pure fairness. If laws constantly changed what was considered legal or illegal yesterday, society would be in total chaos. You need to know the rules of the game at the time you're actually playing it. The crucial point revolves around accrued rights. See, the right to claim damages for defamation accrues the literal second the offending article is published. And legally, a right of action is recognized as a form of property. So just like the government can't arrest you today for something that only became a crime this morning, you also cannot have your right to sue stripped away by a brand new defense that simply didn't exist when you were wronged. The court said absolutely no way can you arbitrarily strip someone of a vested property right they held before April 27, 1994. So the newspaper quickly loses on the retrospectivity argument. But then the court boldly tackled a second, even bigger question, one that would shape the entire future of South African law. Who exactly does the new Bill of Rights apply to? Does it only protect you from the government, or does it directly govern your private, everyday interactions with your neighbors? That brings us to Section 4, vertical versus horizontal rights. This is one of the most heavily debated concepts in constitutional law around the world. Let's really unpack these two concepts. Think of vertical application as a shield against the state. It's you, the individual at the bottom, protected against the vast power of the government at the top. On the flip side, horizontal application would mean the Constitution directly governs private disputes evenly, citizen to citizen. If it's horizontal, you could theoretically use your constitutional free speech rights directly against your neighbor who's suing you. Interestingly enough, when looking right at the wording of Section 7.1 of the Interim Constitution, the court noted it deliberately singles out legislative and executive organs.
It completely omits private citizens, and it doesn't even mention the judiciary. The court figured if the framers wanted the Bill of Rights to govern private disputes horizontally, they would have explicitly said so. Applying it horizontally overnight would have completely upended centuries of established private contract and tort law.
And looking globally, they saw different approaches. Canada's famous dolphin delivery case rejected direct horizontal application, saying their charter was meant to limit state overreach, not micromanage private litigation. Meanwhile, Germany's Luth case pioneered an indirect approach, where constitutional values kind of subtly bleed into private law over time. By looking at these heavyweights, the court confirmed South Africa's vertical interpretation was totally supported by global constitutional culture.
Section 5. Influencing the common law. Okay, so if the Constitution operates vertically, how on earth does it affect a private common law dispute like our defamation case? Does the Constitution just ignore it? Not exactly. The answer lies in Section 35(3). This introduces indirect horizontality. This means courts have to let constitutional values deeply permeate and influence the development of the common law. Think of the Constitution as a filter, not a sledgehammer. You can't use it to just smash a private lawsuit, but judges have to use it as a filter to ensure that traditional common laws gradually evolve to align with these new democratic values. Here's how that works in real life. First, courts acknowledge the new constitutional values, like free speech. Second, they carefully balance that against established traditional rights, like a person's inherent right to dignity. Finally, the Supreme Court slowly, incrementally develops the common law rules to reflect this balance. It's a thoughtful evolution, not a chaotic revolution. They don't just strike down the old laws, they slowly adapt them. Section 6, the final verdict. Let's resolve the underlying tension of our true crime inciting incident. Where did the Constitutional Court finally land?
Acting Justice Kentridge delivered the final answer, ruling firmly against the newspaper. He laid it down crystal clear. The defendants in this case are not entitled to invoke the provisions of the Constitution. You simply cannot reach back in time to erase a private civil wrong using a constitution that had not yet come into existence.
So, what should you take away from this explainer? First, the interim constitution is emphatically not retroactive. Second, the Bill of Rights generally operates vertically against the state. And finally, constitutional values only indirectly influence private disputes through the gradual development of the common law. As for the Pretoria News, their appeal was entirely dismissed, and they were ordered to pay some extremely heavy legal costs.
Now that we know how constitutional values permeate our private law indirectly, I'll leave you with this. As our laws inevitably continue to evolve, in a modern, complex democracy, how will the courts ultimately balance your right to speak your mind freely against someone else's fundamental right to an untarnished reputation? It's an incredibly delicate balancing act, and one that continues to shape our legal landscape today. Thank you for joining me on this explainer.